We all know that real estate has created more millionaires than any other industry on the planet. We also know that it has created a lot of heartache due to mismanagement, overborrowing, and just simple life events that happen to all of us. Welcome to the CashFlowPro podcast. My name is Casey Brown, and I am your fearless leader. And although we might be bourbon sipping and at times foul-mouthed Southerners, we will always do our best to be honest, straightforward, and due diligent with all of the information we pass along to you. Welcome to the show. Hey there, and welcome to today's episode of CashFlowPro, your daily real estate investing podcast and YouTube channel. I am here with Doug Lodmell of Lodmell Lodmell, and we are going to talk today about risk mitigation. We're going to talk about some structuring and some things that you need to keep in mind when doing these deals or investing in these deals. So, Doug, how are you today?
I'm great. Thanks, Casey.
Absolutely, man. We're glad you're here, and listeners, we're glad you're here with us today as well. We hope you can get some education on your mind and start learning about maybe how some of these deals are structured and how they look from the beginning. So, Doug, I'm going to kind of let you take it away with telling us a little bit about yourself, what got you into doing what you do, and then of course we can start talking about legal structures and some things that are just I'm sure there's questions in our listeners' minds. So go ahead and tell us a little bit about yourself.
Sure. I am an attorney, and for the past 25 years have practiced exclusively in the area of asset protection. So helping my clients protect their assets in the event that they do get sued. I'd say in the last 5 years, Casey, it's this whole real estate direction has just exploded. I've always had lots of clients that are involved in real estate, from developers to syndicators. But really, in these last 5 years, it's just, people have kind of discovered the magic of real estate. And so, a lot of people like you and a lot of the listeners, like the ones that are listening here, I'm talking to nowadays. So lots of things we can talk about. You tell me where you want to go and what you want to talk about and what you think your listeners want to hear.
Well, the first thing that always comes up, and I'm going back to calls with investors. People call and they're like, "Hey, I like that deal. That deal looks wonderful. I like the projection of the return. The pro forma looks great. All this stuff. Now I'm going to invest 50,000, but what happens if it goes south and I get sued?" So basically, where I want to start is with the very simple question of what keeps an LP in a deal. Obviously, there's paperwork and so on and so forth to sign that they're saying they're a limited partner, or if it's an LLC structure, a member, whatever. And of course, the legal definition possibly between those two. But what keeps them from being drug in? Because we all see these things, and we all know that when somebody gets sued, like, they name everybody. No matter, I mean, like, obviously some of that stuff gets thrown out, but they name everybody. Anybody and everybody they can conceivably attach to the deal and possibly get some money out of, they attach them all, right?
Well, to a degree, right? So let's talk about those two entities you brought up, the limited partnership and the LLC. Of the two, the limited partnership is an older form of legal entity. They've been around a lot longer. My father actually did syndication deals way back in the 70s and 80s, and he would always use limited partnerships. The distinction of a limited partnership, what makes it unique, is that there are two classes of partner. One is limited and one is general. The general partner has responsibility to manage everything. They also have unlimited liability for whatever goes on in that partnership. Limited partners, on the other hand, do not. They do not have liability. They also do not have any control. So what keeps you from getting sued is being a limited partner, just the fact that you're a limited partner, as long as you don't cross the line into being a general partner. And that's where it can get sticky. So if you are a limited partner, but you're really acting like a general partner, a court may call you a general partner, and in that case, extend liability in your direction. But as far as someone investing in a syndication that's set up as a limited partnership, and they truly are a limited partner, I don't think they have any risk to accept loss of their capital. Clearly, everybody knows, the deal could go south. You could lose absolutely everything you invested. Are you going to be responsible for anything beyond that? The answer is if the deal's structured properly and you're a limited partner, you're not going to be subject to any other liability. LLCs, newer structure, still pretty by now older. I mean, it's been around since the 90s, so pretty well tested. Really a popular structure, very similar to a limited partnership in that there's no shareholders in an LLC. There's just members. Just like there's no shareholders in a limited partnership, there's just partners. That's really an important distinction because when it comes to asset protection, shares of stock in a corporation can be seized by a court. A membership interest or a partnership interest cannot. They're subject to a different set of remedies when it comes to if you end up owing money to somebody and you have assets in the form of an LLC or a limited partnership. Limited liability companies don't have this distinction built into it statutorily. They don't have a general partner and a limited partner. What they have is members. Now, you can, by the operating agreement, you can make different classes of member. You can have managing members. You can have a member managed LLC or a manager managed LLC. But the limitations on liability are also built into that. So if you're just an LLC member, and you're not a manager and you're not signing on any personal guarantees or any loan documents, et cetera, then you can feel pretty comfortable that you are not going to be responsible for liabilities of the LLC if the deal goes bad. Can you lose all your money? Of course, you can lose all your money, but you won't be on the hook for the loan that the managing member might have secured, unless you don't read the documents carefully and somehow you are on the hook. So be sure you read the documents. I mean, that's one of the key things.
Yeah, and that's what we always, we always try to say, make sure you've looked over this before you sign it and read it carefully. And basically, there's no fine print. It's all the same size, but at the same time, it still is ultra cumbersome to hand somebody a 60-page, basically, for lack of a better term, legal document in the form of a PPM or an operating agreement or whatever the case may be,
Right.
and say, hey, make sure you read this, and not only read this, but make sure you understand it. But obviously, we all have in there built in consult an attorney, consult an accountant if you have questions. Make sure you are on the right side of that. And again, we always try to, and I say we as in I'm talking about the industry probably as a whole, most of us try to put forth all of the potential risks up front. Hey, there is a risk. We're going to try our damnedest not to lose all your money, but there is a risk that could possibly happen. And so, I guess all of that being said, we all have to be careful, and as an investor, somebody that's looking to invest in a deal, be careful as well. So,
Yeah.
what now? You talked briefly, and of course, I knew this, but I'd like for you possibly to go back and maybe talk a little bit about statutorily how these things are set up, because I think that's something that we don't get a lot about. And again, this is not a super exciting, like exuberant topic like riding a roller coaster. Again, some of this stuff I get is a little bit grainy and maybe a little bit dry, but I feel like it's of ultra importance for the listeners or potential syndicators or capital raisers to really understand statutorily how these things were set up. And is that at the federal level, or is each deal different in the states? And then, while it's on my mind, let's talk Delaware, Wyoming after that.
Right. So it's state level for all of these things because you have to incorporate or register your LLC or your LP in the state by state. There are, from an investor, if you're a syndicator, there's other rules that apply to who you can solicit and what they have to sign, and your ability to do so in various states. That's beyond the topic here, but the LLC itself or the limited partnership itself is going to be governed by state law.
Okay.
The states differ, although by and large they're pretty similar. So an LLC in most states is going to be pretty much the same. There are a few things that are important to look at, and this kind of also gets into how you as the investor hold your share, or you as the general partner, if you're a syndicator and you're setting up a deal, how you should hold your share. really, as a general rule, your name really shouldn't be on too many things except in the manager line or the general partner line, not the owner line. You would want your own set of companies, holding companies, LLCs, limited partnerships, and potentially an asset protection trust to hold your interest in these things. If you're an investor, same thing. You want your investments to be held in something not your name. So while it's rare that anything bleeds over and out of those types of investments to you, you'd still want to have it in a most likely an LLC or a limited partnership as a holding company. And then you also want to look at it from a protection standpoint. If you have other creditors out there in the world and they come knocking on your door, you don't want things in your name because you don't want your creditors to have access to them. You want them in the companies so that, again, they have to get through these various entities. And that's critical for both sides of the equation. Now, when it comes to Delaware and Wyoming and Nevada, these states have gotten popular because they do, in some cases, some unique things. In the case of Wyoming, for example, privacy is one of the big things that they sell. Privacy meaning when you register an LLC in Wyoming, you can have a nominee organizer organize it, and your name does not have to show up in the public record anywhere, which means that you can create an LLC in Wyoming and nobody can look up who owns it. There's also very good protections in general around the charging order being the exclusive remedy. This gets back into the asset protection side of things. If you have an asset, let's say it's a triplex that you've invested in, and it's worth $500,000, and it's in an LLC, and you end up with a creditor from a car accident, something totally unrelated, and that creditor comes and says, "Hey, you owe me $500,000. I see you have a $500,000 asset right there. I want it." You want to be able to say, "Well, I do have a $500,000 asset in the form of this LLC, but your remedy against that LLC is a charge against my interest. You can't go in and foreclose on the asset, sell the property, and take the cash." That charging order limitation is what begins to give those tools some level of strength in an asset protection context. Wyoming, Nevada, Delaware, and some other states as well, Arizona being one of them, the charging order is the exclusive remedy, which means that the court doesn't have any other remedy. You are stuck with the charging order. Some other states, the charging order is not the exclusive remedy. It's the primary remedy, but the judge has discretion. So California comes to mind. Now, that being said, I will make a footnote here. The judge always has discretion, Casey, always. So while it
no
may
matter
be
what state.
no matter what state. So you might have a Wyoming judge where it's a statutory only charging order protection, and the judge may really not like you and be sympathetic towards the other side. They want to reach a result, and so they find another reason to disregard the LLC altogether. They could call it an alter ego. They could pierce the corporate veil. So regardless of what the statute says, there's just no guarantee that a judge is going to absolutely follow it, because judges have built into our legal system discretion. That's a good thing.
Well, and I think that's the glue that holds it all together, right? The discretion is the glue that holds it all together. Because
right, you have to let the judges have discretion. If we wouldn't need judges if it was all formulaic and was just an algorithm. We could program it into the computer, and then we could just let the computer decide who wins. The discretion is what what makes our system fair, right? So that, yeah, the law says this, but the intent of the law was really not to reward somebody for killing their spouse and collecting the insurance money. So we're not going to let that happen. And that turns into precedent, which other judges follow and say, "Hey, that judge did it that way. We think that's fair." That's what our system is built on, case law. So statutory is the framework of, we're saying how to do it. But as we all know from watching the Supreme Court and other courts interpret statutes, there's still a lot of wiggle room in there. So my point in digressing around all this is simply to say, don't feel like just because you've picked a Wyoming LLC and you've done everything by the book that somehow you're automatically safe from a lawsuit. If you're
Sure.
not the sympathetic party in that suit, you might find yourself on the wrong end of that judge's stick and still lose. That's where we get into other tools that are more advanced, such as the asset protection trust, and we actually remove the assets from the judge's discretion altogether. So there's lots of ways to look at this, but it's important you get it right on the ground by using the right tools and infrastructure, and then that even with that, you still probably need to do more.
Yeah, yeah, and it's always and I guess it's not until there's a problem that you don't realize a lot of times how much
You
more
never know
maybe
till
you
there's
need
a
to do.
problem. That's exactly right. Yeah,
That's
it's
right.
all hunky dory
Now,
until you know.
yeah, and then all of a sudden you're like, okay, maybe I should have what?
Yeah,
So I had a guy tell me one time, and this is just sometimes I benefit from getting to have these discussions directly with people. So this may not be a question that's really out there in listener land, but I had a guy tell me one time that Delaware was so efficient because the law there regarding these corporate structures was so old, like it was very basic, and there, like everything was to the point. There wasn't a lot of nuance to it, I guess. And I guess my question is that the case, or what does Delaware really hold over? Because you see like a lot of places, like everywhere from um, factories or foreign companies, they form in Delaware. They
yeah.
have for years. Wyoming has just now became like a close second, or maybe even a first now. But what is the real benefit to Delaware?
Well, so Delaware is really the first corporate jurisdiction. So almost every public company is registered in Delaware. There's just some serious advantages when you're a public company. That's a real big distinction, though, Casey. A public company that's operating, all over the country or around the world. Delaware is going to universally be the choice. Nobody's going to ever choose Wyoming. When you're talking about a small investor or a syndicator, the advantages of Delaware really just don't apply. They're related
Okay,
to things that are really only applicable to large companies. If you're doing a syndication, you're doing it in Tennessee, you're going to end up with some Tennessee law applying no matter what structure you put in place. So you
sure,
might use a Delaware or Wyoming LLC, but if you go and buy property in Tennessee and that property has an issue and you're in front of a Tennessee judge, what law is that Tennessee judge going to apply? Almost certainly Tennessee
right,
law. So you're not always even
yes,
buying what you think you're buying when you go to a place like Wyoming or Delaware. Um, for the most part, the general rule is that if you're buying property in a state, it makes sense to use the LLC in the state that you're buying the property because you're going to be subject to the law anyway. And instead of maintaining two
and then
different states,
that would keep you from having to have basically two
maintain
sets
two
of.
two different jurisdictions for one LLC. The other way to slice that is that you can take those LLCs and use a holding company, and it's at the holding company level where it makes more sense to go out of state because that holding company is not doing direct business in Tennessee. It might be holding LLCs with properties in 5 different states. In that
Yeah.
case, going to Wyoming or Nevada or Arizona, where we have these favorable laws, starts to make a lot of sense.
Got you. Now that really kind of opens up my eyes a little bit, because I think everybody just automatically says, "Oh, well, let's go to Delaware," and of course it sounds
Yeah,
cool and things like that. When you're talking to people, you sound like an aficionado when you're like, "Oh, I got an LLC that's formed in Delaware."
right.
So I want to talk real quick something. We were talking about piercing the corporate veil and bringing the charge or the I forget
Charging
which
order
exactly they
protection.
called it there
Yeah,
against. Yeah. And the question that I've got is what protections are in the reverse side. So let's say I have a LP or a member that says, "Hey, I'm going to invest 100K in your deal." All right, cool. They bring the 100K, we put it into the deal, we do the due diligence, they're an accredited investor, everything's fine, everybody's happy, but then that guy goes bankrupt.
right.
What what I guess what I'm getting at is obviously there's $100,000 asset there. There's no question
Mm-hmm.
about that. And then there's a return on that asset. There's no question about that.
Right.
But can the bankruptcy trustee call me up and say, hey, man, that guy's got an interest in that property? And then they dive in from there. And to what degrees are they allowed to go forward?
Right. That's why the charging order is the remedy, because they don't want deals blowing up because one investor ends up bankrupt. So the answer is no. The bankruptcy trustee cannot dive in and get that deal. They can't force you to sell it. They can't force you to liquidate his share or pay him out or do anything. All they can do is get a charge against his interest, which is a little bit like getting a lien against his interest, so that when
Okay.
you do pay out, you're not going to pay to him, you're going to pay to the bankruptcy trustee. So you would get a piece of paper saying, hey, this guy's interest has been charged. Before distributing to him, you need to make sure it goes to the right place, and that's going to be to us, to the bankruptcy court, to whoever the trustee says. So that's why charging order protection exists at all, is to protect other members in a diversified LLC or limited partnership. But it can also be used to protect your own assets. So you can put your own assets in an LLC and you still get that charging order protection. Again, if you're in the right state and if the judge doesn't look through it for some reason that they make up.
Sure. Okay. And that makes perfect sense. And I guess that could be the same scenario for divorce or for any other legal remedy that somebody is looking for from that individual or that person. Um, the other idea, and you touched on the word trust, I think, a little bit earlier, but and I know trust law. I don't know trust law. Don't misconstrue that. I know trust law is completely different, and it's almost like doesn't adding a trust like almost fully completely make a like a I don't even know what the right term there is. Like, does it create a complete protection from between the individual and everything involved with the trust being in the middle?
Yeah, so to a degree, the answer is yes. So trust law is very unique. It's definitely different. It is very old. Came over with our common law legal system from England. Trusts are a very old concept that are recognized, and they're very, very powerful. So if I put money in trust for you, Casey, I say, hey, I'm going to put some money in trust, and you're the beneficiary of that. Your creditors are, if that trust is drafted with the right provisions, your creditors can never get to that money. Never, never, never. It's incredibly strong. Where an asset protection trust comes in is that it's that kind of trust to where your creditors can't reach even your own assets, but done for yourself. So instead of me putting assets in trust for you, you're putting an asset in trust for yourself. Now, before 1984, you couldn't do this. There was no jurisdiction that allowed for you to settle a trust for yourself. You could do it for your kids, your grandkids, your brother, your mom, your dad, anybody else, because it's your money and you're giving it to them. And so the courts and the law really respected that because it was never their money. And so their creditors never had any claim to it. However, until 1984, you really couldn't do it for yourself until the Cook Islands passed a statute which specifically allowed for you to do it for yourself and still add in those super powerful spendthrift provisions. Those spendthrift provisions are the provisions that say, hey, the beneficiary is the only one that can use and enjoy these assets. No creditor can do it. Nobody who is not intended to be a beneficiary of this trust. And the reason it worked is because the Cook Islands is not in the U.S. It's 3,000 miles away in the South Pacific. And if you put your money in a Cook Islands trust, the courts here had no jurisdiction. They couldn't tell the trustee, hey, our law doesn't really allow for that, so you can't do it, because their law did. It's kind of like choosing Delaware, but now you're choosing the Delaware of the world. It's out of the country. And so for several years, a lot of U.S. lawyers and commentators said, I don't think we're going to be allowing this. This doesn't seem right. I mean, you're just able to opt out of our legal system and protect your assets. And then in 1998, Alaska said, hey, I actually think that's a pretty good idea. We're going to pass a statute and we're going to do it. And then, of course, Nevada, Wyoming, and Delaware didn't want to get left behind, so they passed statutes. We actually have 19 states in the United States that have a domestic asset protection trust statute. I mean, that's more than a third of the states, approaching half of the states. So it's caught on. Now, the foreign asset protection trust, of which now there's 24 different jurisdictions, the Cook Islands still really being the premier and the first and the best jurisdiction. The advantage of that is strength, because no court in the U.S. has any jurisdiction over there. In fact, the statute in the Cook Islands says that they are prohibited from recognizing any other country's court orders or judicial proceedings. So the Cook Islands Court is not even allowed to recognize, even the Supreme Court of the United States is a zero in the Cook Islands. It means nothing. So the advantage of that is strength, its effectiveness. It really works. The disadvantage
they won't even hear it.
They won't even
right?
hear it.
They just won't even.
They won't even hear it. Well,
like,
you can refile a case down there if you want, and you can try to prove it. You got to prove it beyond a reasonable doubt, which is the criminal standard. You're not going to get a free attorney because they don't allow contingent fee attorneys. You're going to have to pay the costs and legal fees. And if you lose, which almost certainly you're going to lose, you're going to have to pay the legal fees of the winner. So it's an incredibly hard place to go down and try to win a case. But that protection comes at a cost. It's more expensive. Because it's a foreign trust, there's IRS compliance that is pretty comprehensive, and if you fail to fill it out, the penalty is excessive. It's 30% of the assets of the trust. So you really want to think twice before doing a fully foreign trust. You may need to. That may be the right choice. You just have to do it right. The domestic trusts, which we just talked about, they really validated the concept. They kind of basically told all the commentators, hey, not only do we think this is okay for Cook Islands to do, but we want to do it too. The problem is that in the last 20 years or so since these trusts have been alive, the case law has been not nearly as good as the case law for the foreign trusts. And just like we said with the LLCs and the LPs, even though the statute in Alaska says that no assets can be taken out of the trust for a creditor, courts have said, well, yeah, except we're not going to apply that. We're going to apply Montana law, or we're going to apply federal bankruptcy law. And so these trusts really have not held up nearly as well as the foreign trust. And so, you have this, two ends of the spectrum. What I did is I asked myself, go ahead.
I was going to a completely different topic. So go ahead. What you did, what now?
Well, what I did is I asked myself, how can I get the best of both? How can I make it simple to manage and easy and less expensive without the compliance, but still get access to that foreign asset protection trust if we really need to use it? And so I created a hybrid trust, which is called the Bridge Trust, which is really a foreign asset protection trust treated like a domestic trust for tax purposes. So it's simple to use and manage, but has all the effectiveness of a foreign trust. I will typically marry that to a holding company, usually an Arizona limited partnership, and then that would hold all the various LLCs. So if you're a syndicator, you'd probably want to have your syndication, your general partnership share held in an LLC, which in turn is held by your holding company, which in turn is held by your asset protection bridge trust.
Hi, this is Casey Brown, host of the CashFlowPro podcast and YouTube channel. Have you been thinking about investing in real estate but just don't know where to begin? I'd like to help by inviting you to check out our website at www.3000capital.com. There you will find an array of material that will help you learn all about real estate syndication. And while you're there, be sure to check out our free video series download titled 5 Must-Know Keys to Success in Passive Real Estate Investing. I'd also like to personally thank you for making CashFlowPro part of your day. Now, back to the show.
Oh my gosh, yeah. And the layers, and then you just kind of layer one on top of the other in order to, and then that makes it where they have to fight through one, and then they get to another, and then they have to fight through that one, and then they have to get to another, right? I mean, it's basically just like anything else.
Yeah, it's a tough thing for a creditor to get through. My experience with this in the past 25 years of doing this has been that even just having this structure in place usually gets people to the table, usually gets a deal on the table that everybody can live with, and you get things settled. I mean, stuff does happen. You want to just put yourself in a position where you're just not an easy target with your money all just sitting there, tempting them to try to use the legal system to get it from you.
That's right. That's right. And that's what it's all that's really what most of it boils down to. And I think that's what scares so many people away from these deals is because of exactly that. Like it's just like it's just an asset. They know they've got cash. They know there's equity in it, and it's just like it's so tempting for people to use legalities or other means to go after it. And that's what I guess I talk about like people tripping and falling and suing the owner or whatever. You know what I'm
Yeah.
saying? I mean that kind of stuff. Real quick before we get, we're going to go a little over on time here, which I think the content has been extra valuable to the listeners, especially when we start talking about this kind of stuff. But a Delaware statutory trust or a D or I don't think a Delaware statutory trust and a DST are they the same thing or no?
Yeah, same thing. Yeah, DST.
Okay. Now, explain that just a little bit, just a brief definition of that, because I know that comes into play sometimes with 1031 exchanges.
Yeah, so
And
that it's really a 1031 tool. So if you have a 1031, if you have a property and you want to 1031 it, one option is to sell the property and then have your replacement property be an investment in a Delaware statutory trust. It doesn't really have an asset protection component. That's not really what its purpose is. It's really just designed to give you an easy way, and then the property is, your investment is managed through that, and you still get the 1031. It can be very beneficial if you don't want to, 1031 into another specific property and manage it yourself.
awesome. Good deal.
Yeah.
Cool. Well, listen, we're running out of time here, but I've got a couple of questions that we ask every guest that
Okay.
comes on the show. First
All
off, I
right.
want to thank you because your information has been wonderful. And I know that, are you actively taking clients? Are you actively setting things up and working with people like that on a daily basis?
Yeah, so I do take clients directly, and then I also have a network of affiliate attorneys pretty much throughout the country that I work with. So you're welcome to come in through my office and either work directly with me or one of my affiliates.
Awesome. We'll get to how people can contact you and all of that here in just a second. But first off, what is the best book that you have recently read or are currently reading?
Oh gosh, the best book that I've recently read or am currently reading. Some of the classics I still really love. The ability to see how we're connected and how important that is. There's a book called Linked. It's not a brand new book. It's probably 15 years old by now. But that was pretty impactful just to see how it is that really things work. Kind of reminds me of The Tipping Point too. That was a classic, just helping you see what it takes to get to a certain point, and then all of a sudden it just goes all over. I think that's really important as a concept at this moment in time. I did an interview with Bigger Pockets that's kind of in your space, and we talked a lot about the how to hedge in when you're investing in real estate, because everybody thinks this is going to go on forever. I'm old enough to remember 2008. And if you weren't around, I can tell you in 2005, 6, and 7, the word was real estate will never go down. They're not making any more of it. It's basically no lose investment. People found out that wasn't true in 2008. I feel the same energy today. I think everybody kind of the younger generation that were little kids back then that are now adults and trying to make money in real estate. I think there's this concept. It can't go down. They're not making any more of it. Every deal is going to ultimately work out. Well, yeah, every deal will ultimately work out, but you might be dead and you may not be able to survive the bleeding of cash that it would take to hold that deal through a crisis. So don't over leverage yourself was my main message in that podcast. Do not think that it's all about because leverage equals return, right? The more leverage you can use, the more return on your cash. But be careful with leverage because it will bite you if you don't have cash flow to support it.
Yep, that's exactly right. And that is probably one of the best points that I've heard in the last few weeks in doing this podcast is right there. You can leverage, and leverage is good. Yeah. Leverage is wonderful, but unless you have, it's the same as anything else. Leverage your network, but if you don't have the personality to feed that, you're nowhere. And it's the same thing. Leverage your assets, leverage them. But if you ever get to a point where that cash flow doesn't meet that leveraged out position, you might as well be sitting at home doing nothing.
Yeah, you can get burned, and you can go from 250 million to negative in a year. I watched it happen.
Quick. Yeah. Absolutely. All right. What is a dream vacation that you have either taken or hope to take?
Oh man. I honestly, Casey, I don't really see vacations anymore. I just see life. I'm sitting in my dream place right now. I'm in Granby, Colorado, up in the mountains, looking out the window at the stream and the reservoir, and 200 horses over here. So I'd say I'm already sitting right here in my dream. If you haven't been to a place like this, I would strongly recommend it. It's an amazing place. Summer in Colorado is better than even the winter with the skiing. So I'd say Colorado in the summer.
We always used to say in Colorado, of course, when I would travel between Colorado and Kentucky, I had one parent that lived in each spot when I was growing up. We would always go, and they would talk about how it was like 105 degrees in Colorado, and then we would get here and it was like 90, and I couldn't breathe.
Right.
And I was like, "What is?" And then the humidity just breaks you. But no, there's not much better, you're right, than a good, dry, nice Colorado summer day, especially if you're close to a stream where there's any type of trout fishing that happens. You're right, man. You're right 100%. You're living the dream a lot of people only hope to. So listen, Doug, I want to thank you again. I can't thank you enough for coming on the show today, but I want you to tell the listeners how they can reach out and get in touch with you or your affiliate attorneys or whatever channel you want them to take to get assistance from you or reach out and get in touch with you, because there is also some high net worth individuals that are looking for some of this protection stuff that listen to us on a regular basis. And then every once in a while reach out and say, hey, do you have somebody that does this? So tell the listeners how they can get in touch with you.
Yeah, I mean, my website is probably the best place for information, which is just Lodmell, my last name, LODMELL.com. And then if you have a question, just email support@lodmell.com. And if you want to set up a call with me, my assistant will get that support. Her name is Iman. And just say, hey, Iman, saw Doug on CashFlowPro. Would love to set up a call. Awesome. That's it. Easy peasy.
Awesome. Good deal. Doug, thank you so much. And listeners, as always, thank you for listening to the CashFlowPro today. Head down, smash that subscribe button. Again, finger, elbow, ear, eye, whatever it takes to get that subscribe button pushed, knock it out. And also leave us a 5-star review. Please type a review as well so that other potential listeners might know what they might learn here on the CashFlowPro. And I want to thank you again, and I hope everybody has a wonderful rest of the day. And Doug, thank you again, sir.
CashFlowPro is hosted by Casey Brown, founder and CEO of 3000 Capital, a commercial real estate investment firm committed to providing its investors with ongoing cash flow and helping them build long-term wealth. If you enjoyed today's podcast, make sure to hit that subscribe button so you'll be notified about all our future episodes. You can find more information about us and our investment philosophy by clicking the link in the show notes below. Thanks for listening.